Why do I make you nervous?
It's the high pitch. Yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. All right. I'm sorry. Oh.
Oh, thank you.
Thank you.
Sorry.
It's all right. What are we doing?
Your Honor, maybe approach me really quickly.
That's how you want to start my day? Fine. Fine. You're not asking. Jerky says I'm not asking. Yeah, come on. Good approach. All right. Record to reflect the bench conference.
Your Honor, this is an executive preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of the defendant witness in this matter. And we will be authorizing the case promptly as soon as we can.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is on defendant's motion. Thank you.
Thank you.
Court does call the cases of the people versus Tybee Mill.
Anderson representing on behalf of the people, Your Honor. Good morning, Your Honor. Attorney Kevin Basant, T71061. On behalf of Mr. Tybee Mills, the president to my right. Mr. Mills, at your next election.
Than's you.
Today's the date time set for preliminary examination of all three of these cases. Mr. Basant and I have been talking. I don't think there's an objection. We'd be looking to adjourn all three. The primary reason is that the victim in the armed robbery is in the military. He is active duty, but in speaking with the officer in charge, he is willing and should be able to make accommodations to come up here to testify the examination. We just needed to clear things with his command, and they are apparently willing to allow him that leeway to come up here. I believe he's in North Carolina right now. And so we were looking for that, and also the officer in charge on the more recent Bonnet case from 2025 is Officer Kessler. So he's also unavailable. We were looking at, we spoke with the court staff, and I'm not picking a date, but I was throwing a possible date out there of May 13th for an adjourned examination on all three cases.
And Judge, that's right. On behalf of Mr. Mills and his benefit, just for the record, Judge, I would object to an adjournment for this witness not being here today. In the preliminary exam, the witness was subpoenaed. So for the record, Judge, I would object to an adjournment.
All right. In the court, the witness being the individual in the military.
That's correct.
All right. And the court will find good cause to adjourn if the defendant is in military service and can't get up and walk in here. I don't know if this is the type of case, but certainly the court would, if there's no objection for the defense, would also accommodate testimony by Zoom. But
And I'll let Mr. respond. We spoke about that, and I understand his position. I don't think that would be it.
yeah, it would. Okay. And I understand that in terms of that. So what I will do is then I will grant the adjournment given that finding good cause. I'll adjourn the preliminary examination to May 13th. That's when everybody's available and where the accommodations could be made to have the individual.
It's best.
Okay.
That's correct, Judge.
May 13th, 2025 at
And, you know, me and the people approach on a medical issue concerning my client.
certain.
Amazon on behalf of the people, Your Honor.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has. Thank you.
Your Honor, at this time, people are unable to count one. I would ask the court to remand count two to district court.
The brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count one, maintain the plea of not guilty as to count two. This matter will be set for pretrial 1482 district court on
April 30th at 9 a.m. before the court.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right. Thank you. And we'll continue.
Amazon.
Why are you laughing?
Your Honor, Joe, on behalf of Demetrius Mastavostovitz.
Okay, I got everything but one syllable in there. I was close. All right.
Your Honor, today's the date and time set for preliminary examination. At this time, I would ask the court to amend count one to make an attempt interfering with electronic communications, and then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not going to be able to do it that way. I have to, yeah, because what has to happen is count one would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm gonna need the pack code on that one. It's likely gonna be 75545A with a bracketed A.
Correct.
Mr. Simon, any objection to that?
No, Your Honor, thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that charge.
Thank you, Your Honor. Yes.
And court will enter a not guilty plea, maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshour, April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right.
May 6th, but I don't know if that was too far out.
That what, who?
May 6th. So, yeah.
That would be greatly preferred. It's a DV. She likes to hurry the DV docket. But this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th,
May 6th.
10 a.m. before Judge Freshour.
Thank you.
Bond will continue. Thank you. Court does call the case of the people versus, is it Risha Cheatham?
Andrew Childers, attorney on behalf of the people, Your Honor.
And when we are in the business of,
Mr. Simon, get out of the way.
I'm so sorry, Your Honor.
Miss Young was too nice to say that to you, but I'll say it.
Thank you.
Good morning, Your Honor, for the record, reading out 244626. And on behalf of Mr. Shield, two judges present, standing to my right, and would you state the name for the record?
Grace Cheatham.
Thank you. And she's waiving her right to preliminary examination.
Yes,
Is that correct, young lady? All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed in, or the offense alleged was committed in that you committed it. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. All right, people also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Young, you
Oh,
waive.
as to the statement on the information waiver formal reading, as the court did or not guilty plea. Sorry, Judge.
No, it's okay. Defendant every way formal reading, pleading not guilty. Court will enter that not guilty plea to that charge. Pretrial in this matter will be set for
June 10th at 1:30.
June 10th, 2025, 1:30 before Judge Conkey.
Thank you, Counselor.
Thank you. And can I speak with counsel in back, please? I'm Young on a separate matter. Yes, please.
Yes.
All right. Court of standard briefers.
All right.
House on this way, like if it's a one way in this town, you know, it's cancel, pick up speed, and then try to one way. It's like, we used to do it, White House is 14.
All right. The 14A District Court for County of Washington, State of Michigan, is now back in session. The Honorable Judge.
May be seated. Court does call the case of the people versus. All right. What are we doing?
So, Your Honor, cops entered a plea. The offer is to plead to one count of larceny 200 to 1,000, and one count of larceny under 200. Ms. Middleton intends to enter a no contest plea. I've shared the police report with Ms. Vine.
I had it and I've reviewed it. So the plea form indicates that the defendant will be pleading no contest to the charges of larceny less than $200, a 93-day offense, and also count 7 of larceny 200 to 1,000, the 1-year offense. Upon a successful no contest pleas to those charges, counts 1 through 5 would be dismissed and must repay $700 or $700 in restitution.
Yes, that is.
Is that the people's understanding of the full agreement?
That is a correct statement.
May I have her sworn?
You solemnly swear to affirm the testimony about the truth, the oath, and the
Ma'am, it is this court's understanding that you are going to plead no contest to 2 charges. Is that your understanding? All right. First charge is the added count 6 of larceny less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Understand that. Count 7 is charge of larceny $200, $200 to $1,000. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs, and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? All right. Do you understand what a no contest plea is? All right. Let me explain 2 things about a no contest plea just to make sure. First thing you need to understand about a no contest plea. First of all, it means that you're not further desirous or want these charges. You understand that? Yes. All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea?
Lack of recollection.
All right. So, ma'am, to the charge of larceny less than $200, how do you plead? To the charge of larceny $200 to $1,000, how do you plead? Now, you understand that by pleading no contest, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any questions regarding any of those rights? No? Please look at paragraph 5. Those are your rights, which are part of the trial. And by pleading no contest, you're giving up those rights as well as all the rights. Is that a yes?
Yes.
All right. You understand you're giving up the right to appeal of right. Are you on probation or parole? Okay, were you on probation at the time of this offense? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 1513022. Any objection to the court having reviewed that report? Mr. Burdell, any objection to the court having reviewed the report?
No, Judge. My apologies.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court? Court will accept the defendant's no contest pleas to 6 and 7. Counts 1 through 5 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be May 14, 2025, 9 a.m. That is before me. Bond will continue in this matter. All right, thank you. Young lady, since you're here on the left-hand side as you walk down the hallway is my probation department. Just stop in there and check in with them so they can start the process regarding something. Okay? Thank you.
Carolyn Foster Tucker on behalf of Desiree Walker Johnson.
Thank you.
And Your Honor, we will be waiting.
Ms. Walker Johnson, is that correct? You're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes,
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Wait formal reading standing.
Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial will be set for June 5th, 2025, 1:30 before Judge Slay. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case of the People versus Derek Graham.
And is that on behalf of the people, Your Honor?
All two. Thank you.
Your Honor, today is the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to proceed as to count one, as that count 2 be remanded to district court. And in case 25 FB 1109, people to ask the court to add count 2 of misdemeanor stalking, the PAC code 750.411H, and we are unable to proceed as to count 1, would ask that count 2 be remanded to district court.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges count 1 in both files be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed. Continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for for in custody. Before I give you a date on that, let me.
We're gonna ask the court for bond on that matter, Your Honor. So if you could just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking. In the PAC code on that.
750.411H, 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation.
I'm sorry, Your Honor, my client was asking me.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right, count one in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they are, they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
Sorry?
Miami Avenue in Ipsy.
That would be his home address, Your Honor. I just didn't know whether the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't, is that, all right, okay. All right, so people's response.
Your Honor, we would object to any modification of, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark your ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you with broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but she did recently on Friday and that she was on board. We have great concerns. And I also believe he has a hold out of Jackson County for trials as well, Your Honor.
If that's the case, I was unaware of that part. Your Honor. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, with regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victim a day or 2 before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were from
sorry.
what he sent the victim's phone that led to the charges.
So he was out, he was not in custody when he allegedly made these threats and nothing happened to anybody. So Mr. Graham doesn't get insulted, was running his mouth, right?
When he's out, is he working or?
He's been in custody for a while, Your Honor, I assume, so I don't know the answer to that question.
Got it.
Charge set up for April 1st, and I said it on this misdemeanor, and they I had one that prosecutor was Woods, and it was addressed, so it should have been a problem. I had a job, I was going to start April 1st. And I think they need to go to the bond, but she said she wanted to see after this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right, thank you.
Just one moment. My client seems to think that the bonds are $50,000.
10% bid.
Did they get changed at some point?
Obviously, the bonds I had originally, Your Honor, were both 100,000 cash surety, but were not changed.
He's on 2 felony cases.
And then he has a misdemeanor case of now he's the same victim, I believe, in 14
So
feet.
he's
So
reducing
he's that bond referring to?
No.
It's 100K cash surety.
Yeah, that's what I have.
That's for the felonies.
On these 2 cases, I had 100,000 cash surety on each case. All right, thank you.
Thank you.
He was right here.
I did see him come in, but I didn't see him walk out, so.
Feaster. Where'd he go? What? What's he doing? Is he just messing around doing nothing? He's just standing there? What, loitering? Oh, him and McDuffie. Oh, boy. About time, Feaster, you showed up. Huh? We've been waiting for an hour.
Sorry, Judge, I was next to the door was Judge Moore. I apologize.
Oh, you rather be there?
No, Judge. I said-
No, really, I'll tell her that.
She's so new, I haven't had a chance to talk to her yet.
Got it. What are we doing on your case?
Thank you, Judge. I'm going to do a waiver of circuit court on this matter. This time there's no mystery in offer. My client is in custody. And she will be.
Did you want to go talk to him before they're doing this, or?
She knows.
She knows.
Okay.
I haven't called it yet.
Call her out.
Yeah.
Can we get it correct?
Court, that's called the case of the People versus Haley Gregg.
If you were to the first people.
Marshal Feaster, Assistant Public Defender on behalf of Ms. Gregg. Ms. Gregg, when you get to the podium, please state your name for the record. Here we go. Thank you, Judge. Date time set for preliminary examination in the matter. I have spoken to Mr. Duffy, Ms. Gregg. At this time, the case has been offered. Would you like to make this time second part for the resolution?
Ma'am, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive the right.
Yes, right.
Preliminary examination have been waived. Defendants bound over to circuit court on count 1 with 2 following. Mr. Fisher.
Judge, we'll wait for a reason to stand mute.
Defendant have a waive formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon. Bond will continue.
Judge, I just want to address.
Oh, go ahead.
Thank you, Judge. My understanding, Mr. Duffy, is that Ms. Gregg does not have a horrible history. Obviously, this case, the allegation is that Ms. Gregg is acting out of character for herself. She is ready to take responsibility and resolve this matter, hence the waiver. She is asking the right to consider the reduction of her bond and a possible release. She has no problem with attending. She would have no problems with attending and following our court orders. In the meanwhile, I'm going to look into possible treatment courts for Ms. Gregg. And she said that she would follow. I believe she wants to address it. I didn't really don't talk about what happened in this case. Why did you want to talk about? I didn't have why I didn't do like court misstep. I had other issues, but I had to chuckle and my phone wasn't there. I know it's not really an excuse, but I didn't really have a way to communicate with anybody, and I was scared. I didn't know what to do. I've never been through this situation. I usually, if I get arrested, I find myself out when I come and I pay my fees. This has been a terrifying experience. I'm not used to any of this. I don't know what else to say other than I'm sorry. I was on my character. I wasn't on medication.
So,
Yeah, I've been on my medication. I've been.
okay, let me ask you this. You failed to show, the reason she's in is because she failed to show in February, and I issued the bench warrant. So let me ask you this. What happened after you didn't make that court appearance? What'd you do?
Really nothing. I tried to survive out there. I was home. What Judge asked me to do is.
Okay.
Why did you not come set because of his office or the court? I didn't know what to do. Like I said, I was scared.
Okay, that's what you were talking about. Okay.
Mental health proceedings and stuff like that.
Okay. So let me ask you this. How'd you come back into custody? What happened?
Somebody actually told the police where I was at. And they knew that I had a felony warrant, I guess, that they came to the hotel and I didn't know, that's how much I don't know. I opened the door. I was like, hi. They're like, Haley. I'm like, hey. They're like, yeah, let's go. So I was like, all right. Yeah.
You mean that's how you were talking to the police?
Yeah. We're okay. I mean, I don't, the police, they don't really bother me. They know that, they like me, but they don't. This sounds like a match that this Greg was off the medication. It sounds like she's not on her medication. It sounds like she's been in custody since February 21 days, 21 additional days. She has no problem with the tablet, 100% necessary. She's hoping around consider release. Based on the fact that she's waived, it's taking some residence responsibility.
Any response from the people?
Your Honor, I don't have any, objection to her being released. I'm not sure where the situation is now, where she's going to stay. But given that the location, I think, of the underlying incident was around the Kamana Center, she mentioned she didn't have stable housing. So if there is a tether order, a GPS tracking tether might be appropriate.
Well, I'm not gonna put her on a tether. She has enough problems trying to find housing and put a roof over her head.
I mean, the one that I did have, I was there
And then you're gonna have to get back on the list to get, I know how it works.
Oh, I am, that's why I was so upset, you know, myself. Like, I'm in the house, like, the housing list, you know what I'm saying? I don't know how this all works. You know how it works. And so, you understand the difficulty that I have trying to get back into someplace for the sake. I'm gonna stay here. That's not what it said. Oh, no. I'm terrified right now, I'm shaking.
You're what?
I said, I'm just terrified, I've never.
You're shaking right now?
No.
Why? Do I make you nervous?
No.
Why do I make you nervous?
It's the high pitch. Yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. I'm like, such a kind and gentle soul. I don't know why. Whoa, Emily, you didn't have to have that response. Wow. Alan, you could have stuck up for me. You could have. No. Wow. Everybody's just turned on me. All right. Miss Gregg, here's what I'm going to do. I'm going to reduce your bond. All right. In this case, I'm going to reinstate it back to what it was, to a $15,000 personal recognizance bond. Now, in doing that, Ms. Gregg, you got to make sure your next date is the 7th. You make sure you get there. You hear me?
Yes, sir. Yes, Your Honor.
Okay.
That face.
You didn't even think that would happen, did you? Okay. You get out today. You're welcome. Take care of yourself. Wow. She did better than you. Alan wasn't going to do anything. He just, see, Alan, he's hard. Wow. Is that it for us? 14A stands adjourned.
The 14th District Court, County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning, everyone. Court does call the case of at Lakeside versus Lorianne Pedersen.
Ready, Your Honor, so appearing on behalf of AT Lakeside site.
Oh, it's AT Lakeside, not at
AT Lakeside.
All right. Lorianne Pedersen, she's here.
Yeah, I see her, yeah.
She's been dropping in and out this morning. I was letting her initial convocation may not have heard you.
Yes, I'm here.
Okay, I need a camera.
Yeah,
All right.
I'm trying, sir. I'm sorry.
Okay. All right, we're good. We'll start while you're working on that. Mr. Lloyd, how much is the plaintiff's claim in this case?
The plaintiff's claim for the rent is and late fees is $3,090. We have $227.80 in court costs. Total of $3236.80.
$3236. All right, Mr. Peterson, how are you intending on trying to get that paid?
I filled out my taxes, Your Honor, and I should be getting that back any day now.
Okay, so you're looking at paying that with a tax return.
Yes, sir.
All right, what I'll do, I'll make a note of that. I'll give you the 1 week adjournment and let's see exactly where we are at that point before we have to do anything on it, okay?
Okay.
I'll adjourn this then
will I be
to,
getting sort of?
I'm sorry?
Go ahead. I just didn't receive anything in the mail with the password. I was hoping that I could receive that in the mail this time.
With the court date?
Yes, sir.
Well, I'm gonna give it to you right now. You may get something in the mail, but I'm not responsible for how slow or fast the postal service works. Okay?
Okay, great. Thank you.
All right, April 25th, 2025 at 2 p.m. That's an in-person hearing, okay? So if you get your tax
Okay.
return, get it paid off, hopefully then they can dismiss the case, all right?
Okay,
Happy to
and
do
I'm
it.
still, and I'm still supposed to pay this at the Huntington Bank account that John Smalley gave me?
You would pay it as you normally would.
Yes. But
Well,
if you have, go ahead.
go ahead, Mr. Lloyd.
I was gonna, if you have paid it and you would call my office, then I'd like to be able to confirm with him because I'll make sure I'm getting, I will call John, but if you've paid it, I want to make sure he knows it. So
Okay, and if I've paid, do I still have to show up at court?
if you've paid it, we'll all be done and I'll file a dismissal.
Okay, great.
If you've paid it. So,
All right, sounds good. All right, thank you.
All right,
All
thank
right.
you.
thank you, Your
Thank you,
Honor.
Thank you, Mr. Lloyd. Take care of yourself, please.
Yes.
Northwood Property versus Robert Gould.
Bert Lucas for Northwood Property. Good morning, Your Honor.
All right. Is Mr. Gould, oh, there he is. Mr. Gould's there. All right. What is plaintiff's claim in this case?
Plaintiff's claim is $4,800 for rent and late fees, $164.40 for a total of $49.64.40.
Mr. Gould, how are you intending on getting that paid?
I'm not sure, Your Honor. I'm trying to get a hold of my caseworker because the Navy's supposed to be paying my rent. And I'm not
Who
sure
is?
what's going on. The Navy?
Okay, so you're a veteran?
Yes, sir.
All right. And they're supposed to be paying it, so you're trying to get a hold of your caseworker?
Yeah, they were paying it. I mean, like, I don't know what happened, but I've never paid Northwood or anybody since I've been here.
Got it. Okay. So what I'll do is, so that's like 2 months rent or 3?
4 months.
4 months? Okay.
I never.
All
This
right,
is the first
so-
time I've seen a copy of my lease, anyways.
Pardon?
This is the first time that I've gotten a copy of my lease, anyways, since I've been here.
Okay. All right. Here's what I'll do. I'll adjourn this out to April 25th, 2025. Let you try to get in contact with your caseworker, okay?
Yes, sir.
And let's see what happens. So, and what time is that?
2 p.m.
At 2 p.m. Okay?
Okay. Yes, sir.
All right. Thank you, Mr. Good. Boom.
You have a great day.
Thank you.
You do the same. Court does call the case of Bushwood Properties versus Craig Mattingly and Stacy Stoba.
Good morning, Your Honor. David Fancher on behalf of the plaintiff.
Mattingly, Stoba, no response. If you raise your right hand, I take it vote. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Your Honor,
Go
I'm
ahead,
David Fancher. I'm the attorney for Bushwood Properties, and as such, I'm familiar with the books and records as they relate to these tenancies. In this case, there's rent owing in the amount of $3,912.38, court costs of $188 for a total of $4,100.38. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested, writ issue in 10 days. Danny Noonan, LLC versus Sean Cummings.
Good morning, Your Honor. David Fancher on behalf of the plaintiff.
Sean Cummings, I see your name. You'll need to unmute, turn on your camera. Sean Cummings, oh, there you are. All right.
Hello, Your Honor.
Hello, sir. All right, Mr. Pantera, what's the claim in this case?
The total balance, including court costs, is $2,908.85.
All right, Mr. Cummings, how are you intending on getting that paid?
I have contacted Hawk and I have an appointment with them on at 2 p.m. with a caseworker, so I couldn't get
You're a
it.
bit muffled. Is that us? Okay, say that again, sir.
I contacted Hawk and I have an appointment with them on the 26th at 2 p.m. with a caseworker to like give me the
Okay, you said, hang on a second. Your mic's a bit muffled. You say you have an appointment on the 25th?
the 26th.
26th. That's Saturday.
Yes, at 2 p.m.
Okay. Well, I don't know that a 1 week is gonna do it then, but
You know, I don't have a problem if, I mean, I doubt he's got an appointment on a Saturday, but I don't have a problem if you want to adjourn this out 2 weeks so that we can actually
Okay.
have the appointment.
all right. May 2nd, 2025 at, do I have that date?
Do not have second hearing.
I do not have second hearings on the 2nd because of the bench bar, right?
Not correct, and then the next week is that other conference, so not till the 16th.
Okay, so I had the bench bar on the 2nd, so I don't have second hearings that day. I only have first hearings. There's a statewide judicial conference on the 9th. And so my next date, quite frankly, is the 16th.
Can we just do next week and I'll contact the worker and see what I can do?
All right.
Mr. Cummings, who is the worker? Do you know? Who's your appointment with?
Oh, yeah.
Say again?
I don't know.
All right, I'll reach out, Your Honor, and see if we can get it done.
All right.
Before next week.
So April 25th, 2025 at 1 p.m. All right.
Thank you.
That's in person. Thank you, Mr. Cummings.
Okay, thank you.
Mrs. Haverkamp versus Alexander Jackson.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
And Mr. Jackson, you there? There you are. Okay. And how much is owing on this case?
Including court costs, $2,160.
$2,160. Okay, how are you intending on getting that paid? Oh, I don't know that I can hear you. Well, I know I can't hear you. Oh, that might do it.
Can you hear me now?
Yes, I can hear you. You'll have to speak up. You're a little bit low, but we can hear you.
Can you hear me now?
Yeah, we can hear you.
Awesome.
Well,
I said I plan on contacting Hawks and DHS today.
You have you contacted them already?
No, I plan on doing that today. I didn't have their resources.
You'll be doing that today. Okay, I'll give you an opportunity to do that. I'll adjourn it out a week, April 25th, 2025, 1 p.m. Okay, get that done. Make sure that you do that, okay?
1 p.m.
1 p.m. That's in person also, okay?
in person at 14th District.
I'm sorry?
In person? You at this court name?
Yeah, at 14A1, down by the Sheriff's Department.
All right, thank you.
All right, thank you. Mrs. Haverkamp versus DeAndre Cersei.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
He's there. He's staring at the screen trying to get that mute button off, so I'm gonna let him work on it.
Can you hear me?
He got it. Okay.
All right.
Mr.
How you doing,
Cersei.
Judge?
I'm doing okay. How are you doing, sir?
All right. So can I go ahead?
Hang on a second. Let me find out how much is owing, Mr. Fantera.
The current balance on this case is $5,606.
Okay, Mr. Cersei, how are you intending on getting that paid?
Well, before this happened, we set a great payment plan, and I talked to her in May, and she said, "Can you hear me?"
Yeah, I can hear you.
Well, we talked to the landlord already before all this came up, and she said for April, if I pay $750 by April 3rd, we will remove $100 late fees, and every time you pay 300 additionally with my payment plan, they will remove my fees. I already paid $750 for April. I'm on SSI and I'm on Social Security because I have one arm. So I wanted to pay the agreement we have for $750 until I can get this paid off. And at first, my caseworker, I've been having a lot of problems here. And my Section 8, we couldn't find the landlord because they ran through 3 landlords. First, it was Bill's Property. Then it was Red Line or Red Green.
Red
Then,
Lion?
yeah,
Red Shield, Your Honor.
Red Shield.
Okay.
Then
Oh,
it was,
Red Shield.
yeah. Then it was the landlord now for the building. So that's why I'm actually build up on this because we couldn't find. I had my caseworker trying to find the landlord. I had Section 8. They was calling me talking about who do I pay the money to. For them 3 months, Section 8 had to pay 4 months of late fees back in 2000. I've been there for 4 years, so it's been like since 2003. And as you see, I've been playing on. They've been working with me, and we set an agreement payment of paying
All right.
$750 a month till I get this paid off.
Okay, hold on. Mr. Fantera, you know anything about any of that?
I don't, but I've got his ledger in front of me, and I do see a $750 payment on April 3rd. And I'm certainly willing to honor whatever agreement that they've come up with. Can Mr. Searcy put his phone number in the chat? And
Yes.
then I'll contact him before next week and see if we can put something.
Passed up in court, Judge Simpson.
See if we can put something in writing before we come back, Your Honor.
Yes.
Okay. So I'll adjourn this out to April 25th, 2025.
That's my birthday.
At 1 p.m. That's what?
That's my birthday.
Well, good. I get to celebrate your birthday with you.
I know. I hope it be a good thing. Hey, I'm about to bring cupcakes for us.
Actually, Mr. Searcy, I have a phone number here on your ledger. Are the last 4, can I say the last 4 digits, Your Honor?
Yes, you can.
2609?
Yes, sir.
Okay, I've got it, Your Honor. I don't need him to put anything in the chat. I'll be in touch.
Okay.
And he also might want to apply, because he's on SSI, he might want to apply for Hawk because they might be able to help him, which, would, either reduce the total balance or maybe eliminate everything altogether. But he might want to do that before next week.
Yeah, I talked to
All
Hawks.
right.
I talked to Hawks, but I had an interview on April 2nd, and they never called me back for my phone interview.
All right, I'll call them. I've got to call them on another case. I'll see what I can do about, see if there was a mix-up. Maybe they can reinstate it. But I'll talk to you before next week.
All right, sir.
All right. Thank you, Mr. Searcy.
Thank you.
Good luck.
Yeah.
Mrs. Haverkamp versus Murad Naeem.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
You got him at all? No. Naeem? No response. You've been sworn. You may proceed.
In this case, there's rent owing in the amount of $1,941, court costs of $175 for a total of $2,116. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Sandy McFiddish versus Parker Davis.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Parker Davis, no response. You may proceed.
Your Honor, in this case, there's rent owing in the amount of $2,461.34, court costs of $175 for a total of $2,636.34. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Walkabout Creek versus Rochelle Ritchie.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Rochelle Ritchie? She was here this morning. My staff is telling me, but we don't, not here now. You may proceed.
In this case, there's rent owing in the amount of $699, court costs of $170 for a total of $869. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. YPF 16 LLC versus Christina Morgan.